5679, Representative Lauer, changes to Michigan Sex Offender Registration Act. We do have the representative here to testify. I will speak to the representative and to everybody else who will be testifying going forward to keep your comments as concise as possible, as we do have large interest in testimony and in this bill. So thank you very much, Representative.
Well, thank you, Chairman Filler, and certainly committee members, and I will keep it brief. As you've noted, I think there'll be a lot of discussion on this issue today and as we move forward as a committee and a legislature. So House Bill 5679 provides necessary updates to Michigan's Sex Offender Registration Act in response to a recent court ruling. Without this reform, the state soon will be unable to enforce certain sex offender registration requirements due to the court's ruling, and we must update the law to ensure the protections remain in place for Michigan families. And the plan that I put forward reflects the court-ordered changes to protect the due process rights of the citizens. The plan also provides much-needed clarity for law enforcement and offenders on the registry. This makes the law easier to follow and also easier to enforce. If we were to not act and do nothing, the Michigan SORA, with a plan that I put forward or one very similar to it, sex offenders who committed crimes prior to 2011 will not have to comply with SORA at all. Those convicted after 2011 would also see greatly reduced registration requirements. I'm going to attempt to provide the committee with a boiled down basic explanation of why parts of the law were ruled unconstitutional and how that basically ended up affecting the whole law. So the court has deemed that the 2006 and 2011 updates of SORA function as additional penalties or punishments, and therefore applying those updates retroactively to those convicted prior to the changes is considered by the court to be an ex post facto law. This type of lawmaking is, as many of you know, explicitly banned by our Constitution. Additionally, because the 2006 and 2011 updates are so intertwined and interconnected with other parts of the law, the court felt it could not easily separate the constitutional and unconstitutional portions of the law. And they also felt, and correctly so in my opinion, that writing law is the job of the legislature, not the courts. So they've ordered the legislature to perform these revisions and updates. So going forward, my plan's pretty simple and basic in terms of trying to follow the court ruling. It creates essentially a two-tiered system as required by the court. Those convicted prior to 2011 will be subject to the requirements that were on the books at the time of those convictions. Those convicted after 2011 can be subject and will be subject to the updated requirements that were passed at that time. That way you don't run into this ex post facto issue. Many of the issues the court noted that affect all offenders that weren't deemed unconstitutional because of their after-the-fact nature, such as moving around, having to report in person to law enforcement right away, vagueness related to telephone number requirements, email addresses, vehicle models, aircraft, boats, et cetera, is also addressed by the legislation. So those provisions were deemed unconstitutional because of their vagueness, not necessarily because they were simply put in place after the fact. So like everyone on this committee and this legislature, I really strongly believe that due process rights are very important, but the rights of crime victim survivors and the rights of potential targets of sexual assaultive crimes are also important. And what we're attempting to do with this bill is balance all of those things. You know, it's likely that, you know, after I'm done and, you know, as this plays out, we'll hear a lot of testimony and arguments against, you know, having SORA generally speaking. I'm trying to stay focused on how my bill addresses the changes the courts required to keep our current SORA functional. I think that's hopefully the topic for today. Hopefully we can all agree that we should have SORA and that we just need to make these changes and not have a conversation about throwing it out entirely. I think that, you know, punishments for crimes usually come in two basic forms. One's to provide justice to the victims. The other's to serve as a disincentive or a deterrent for criminal activity. But I think SORA provides a third as well. I think in some ways it helps us keep dangerous individuals away from vulnerable members of our society without keeping those perpetrators in prison in perpetuity, which is obviously costly and difficult to do. So I think it adds a protective element in addition to the justice components and hopefully the disincentive components as well. So for those reasons, I think that the law as it stands is worth fighting for and is worth making these needed revisions. I'd also like the committee to consider my testimony today and today's hearing the beginning of the process for SORA. Obviously, we introduced this bill right before the COVID-19 pandemic hit. It was our attempt to get a bill in and start the conversation as soon as possible because the court ordered basically a 90-day window for the legislature to act on these updates. Now, that window has been put in what I would call a legal limbo as it stands right now. So what I'm saying is I think it's important that we act as quickly as possible on this so we don't run into an issue where, where the law becomes entirely ineffective and then becomes re-effective or something like that. I think that would create a lot more problems. So what I'm saying is I'm open to, whatever criticisms or comments that you might have with the introduced version. What I'm hoping is that we can work in a bipartisan fashion to, fix whatever those issues might be and get a bill onto the governor's desk as soon as possible. And with that, I'll take any questions.
Thank you, Representative. I don't see any questions right now, so thank you very much for your testimony.
Well, thank you, Chairman, and thank you, Committee, for taking up this really important issue.
Next, we have multiple groups that either sent in written testimony or will be testifying. And I do have a letter here that I'm going to read from MSP, and this will be provided to all the members of the, I'm sorry. Okay. All right, so this is State of Michigan, Department of State Police, Tim Fitzgerald, MSP, and he wrote a letter which essentially lays out the three main points they'd like this committee to be aware of going forward. And so I'm going to read it, and I will skip over the sections, but this has been provided to each committee member. Department of State Police is supportive of the intent of House Bill 5679 in amending SORA and is looking forward to working with Rep. Lauer on addressing the constitutional concerns recently noted by the U.S. District Court for the Eastern District of Michigan. Additionally, we look forward to addressing several issues within SORA in an effort to improve efficiency and functionality of the sex offender registration process for both offenders and law enforcement. And they highlight three main points, which I will quickly go through. Of note, the department would initially like to highlight the following areas. The department supports removing the student safety zone provisions. In addition to the historical difficulties often encountered when attempting to define the boundaries of these zones for the purpose of enforcement, the department has been advised by its attorneys in the present litigation that because the student safety zones were found to be unconstitutional and unenforceable, any effort to retain the student safety provisions would almost certainly result in further litigation and a similar determination that zones are unconstitutional and enforceable. Number two, the department has concerns about the way the individuals with out-of-state convictions requiring registration in that state will be treated if the individual decides to reside, work, or go to school in Michigan at any point. Any revision of SORA should ensure and clarify that an individual convicted in another state of an offense requiring sex offender registration in that state should, at a minimum, be required to register in Michigan for a similar duration under substantially similar terms regardless of the date of offense. Otherwise, registered sex offenders from other states with offenses prior to Michigan's 2011 amendments to SORA could seek sanctuary from all sex offender registration by simply relocating to Michigan. Number three, House Bill 5679 attempts to address the constitutional issues surrounding the use of vague terms like regularly operate and routinely used by adding the term primary to the definition of these terms. The department has been advised by its attorneys in the present litigation that adding additional descriptive terms such as primary will likely result in continued litigation or claims for vagueness. And then MSP appreciates the committee taking the issue up and recognizes the opportunity to improve and simplify the process for both offenders and law enforcement agencies. So that will be provided to each member of the committee. And next we have testimony from Kathy Haganian, MCE DSV, and she has 5 minutes to testify. And Kathy, are you on the Zoom?
I am on Zoom, and I believe I'm unmuted, and I am going to try to put myself on camera here. I think that'll work. Am I live?
Yes, Kathy, can you hear me?
I can hear you. Yes, can you hear me?
Yes, please, go ahead.
Great. Thank you so much, Mr. Chair and members of the committee. Thank you for the opportunity to speak on behalf of the Michigan Coalition to End Domestic and Sexual Violence, our 73 community-based member programs across the state, providing services to victims of sexual assault and domestic violence. I would like to mention, just take this moment at this time to let all of you and all across the state know that our programs are still operating. We are there for survivors 24/7. Our workers are going in when they need to, frontline, essential service workers, and we are there for survivors. So if you or anyone know anyone who does need support or services because of domestic violence or sexual assault, please do encourage them to reach out. There's help available. There's hope. They're not alone, and our programs are there. As advocates for justice for survivors, as well as social justice and public safety, MCEDSV is committed to ensuring that our laws and policies concerning sex offenders who are not incarcerated advance survivor and public safety, reduce recidivism, and promote potential for positive societal contributions. Historically, the coalition has not been opposed to some limited sexual assault registry reforms, provided that the foundation and public discourse of any such reforms begins with recognizing the significant impact of sexual assault on survivors, their loved ones, and our communities. Clearly acknowledges perpetrator responsibility for sexual violence, and is evidence-based using research and guidance and expertise accepted by the sexual assault survivor response and advocacy field. MCEDSV understands the need to amend Michigan sex offender registry laws in order to bring our statutes in compliance with the court rulings concerning constitutional issues. As such, we support House Bill 5679 in principle. At this point, we are continuing to look very carefully at the details of the bill and analyze it in light of the review and feedback of our other key state stakeholders in these issues and state partners. We do want to ensure that we have not inadvertently missed any technical concerns or unintended consequences in our final review of the bill as written. That's basically our statement at this time. Just in conclusion, again, I'd like to thank you very much for the opportunity to testify, especially remotely, and thanks to Nick for making that happen. I also want to thank all of the committee members and staff at this time for your continuing work on behalf of all of us during this very unique and these difficult circumstances. I'm available to answer any questions now or later in the hearing if needed. Thank you.
Kathy, thank you again. I don't see any further questions, but I'm sure if people do, they know where to find you.
Indeed. Thank you.
Okay, good seeing you, Kathy.
Good to see you.
Next, we have Jill Levinson and JJ Prescott from the ACLU. Are they both on the Zoom, or will one be speaking followed by another? Okay.
Okay, there we go. Now I think I'm muted. Good morning. My name is Dr. Jill Levinson, and thank you for having me testify this morning. I'm a professor of social work at Barry University in Miami, Florida, and for 20 years, my area of research expertise has been sexual perpetration prevention. I've studied the impact and effectiveness of policies.
That's so weird.
I've studied the impact and effectiveness of policies designed to prevent repeat sexual violence, and I've also studied the effectiveness of treatment interventions for convicted sex offenders. I do not work only in the ivory tower, however. I'm also a licensed clinical social worker, I began my career as a child protection worker and a sexual trauma therapist, and I do understand the far-reaching impacts for survivors. I still work with survivors, but I also work in a mandated outpatient sex offending treatment program. I've been doing that since 1992, so I'm still on the front lines and every day speaking with people who have committed these crimes and with their probation and parole officers. I have the easy job, though. Your job is much more difficult. I know that you are trying to balance the needs of public safety and fairness and empirical evidence. No policy or intervention is ever perfect, and it can be really challenging to evaluate the pros and cons and risks and benefits of the various intended and unintended consequences of laws. So thank you for your public service, and thank you for having me here today. I have a PowerPoint that I'm going to share my screen with, but I want to just start by saying, as a mother, grandmother, and as a woman, I want us all to live in safe communities. And as a social science researcher and tax-paying citizen, I also want our laws to be effective and cost-efficient. So I'm here today to speak with you about how you might be able to make your registry most effective in reaching its stated goals. So I'm going to share my screen, and I don't know if you received a copy of this PowerPoint before today, but can you see my screen now?
We can see your screen, and I do not believe that we have received, we received it this morning and we'll share with the committee.
Okay, and okay, you did receive it. That's great. And again, my goal is to just share some ideas based on my own research and my knowledge of the research literature and my experience in this field to help you make the best decisions for public safety and to support survivors, of course. So I think the first question I almost always get asked is that there is this perception that all sex offending is predatory, that all offenders are destined to reoffend, that they're unable to be treated or rehabilitated, and whether or not that's really true. So just to put this in context, it's important to remember that the term sex offender is a legal term. It's not in and of itself a diagnostic a psychological diagnosis. There are psychological diagnoses, but sex offender is a legal term. We know also that all sex offenses and all sex offenders are not the same. They're a very heterogeneous group. And that means that the existence of some sort of paraphilic disorder, if it does exist, and risk or dangerousness all exist on a pretty wide continuum. So I think an analogy, excuse me, that we can all understand is that just like every drunk driver, every person who's arrested for drunk driving doesn't necessarily meet the criteria for alcoholism, or every person who's arrested for a drug possession doesn't necessarily meet criteria for a substance addiction or dependence. Not every person who is arrested for a sex crime meets a definition for a paraphilic disorder or is at high risk to repeat that behavior. And, so I think that we can all understand that there's a difference between different types of offenses and people who commit them. And we may view, again, I'm saying this not to diminish the pain or suffering of victims in any way, but just to sort of recognize that there may be a distinction between a young adult who has what he perceives as perhaps unlawfully, but perceives a consensual teenage partner, as opposed to a person in a position, an adult in a position of authority who uses that trust and familiarity to engage in predatory behavior and abuse young children. And so that said, we know that recidivism rates are actually lower than commonly believed. And this isn't actually surprising because, as we just discussed, most people on registries are actually lower risk offenders and don't fall into that paraphilic, predatory, repetitive kind of pattern. Some do, of course. And so, the important and maybe most difficult task for legislatures is to try to figure out how to protect the community from those people who do pose the greatest risk, while also allowing for the successful reintegration of people who may not continue to pose danger over long periods of time. When we, if you know anything about research, you probably know that every sample is different, and every study, depending on the methodology of that study, might come up with different recidivism rates. But when we look at the totality of the literature across the entire United States and North America over many, many decades, we know that sexual recidivism rates average anywhere from about 3 to 15%, depending on the follow-up period and depending on the study. But what is true across the board is that the vast majority of people convicted for sex offenses are not subsequently rearrested for a new sex offense. And while it is certainly true that some people commit crimes that are not detected or for which they are not arrested, we also know that people on registries or who are on probation or parole are under increased scrutiny. So they are more likely to be detected for a subsequent offense. What we know, again, from longitudinal research over almost 3 decades now, is that the longer a person who's convicted of sex crime lives in the community offense-free, the less likely they actually are to reoffend again. Now, like anything else, this isn't a perfect formula. Are there some people who are able to be deceitful and live in communities for long times and go undetected? Yes. But that is really the exception rather than the rule. So we know that over time, looking at tens of thousands of people who have been arrested, convicted, released, and followed, their risk for committing a new offense goes down as they spend more time in the community offense-free. And so the best evidence of this we have is a series of studies that has gone on for 25 years by the world's leading researchers who, some of whom are from Canada, who operate in Canada, and some in the United States. And they have been following groups of people convicted of sex crimes, as I said, for about 2.5 decades. And what that means is, starting 25 years ago, people are arrested, and then they continue to watch them throughout their conviction, incarceration, release, probation, parole, et cetera, and then document who reoffends and what are those people like and what are the risk factors that are contributing to that, and overall, what are the longitudinal rates. And what you see here, I'll try and make it as easy as possible. What you see here is a graph. At the bottom, this is the number of years living in the community offense-free. And what happens is, you can see over here on the left, most people who reoffend actually do so more or less fairly quickly after their initial release. Over here toward the right, you're seeing that this top dotted line is the above average risk, the highest risk offenders. And then this next red dashed line are those who are above average risk. The orange is average risk, the average risk of the average quote unquote sex offender. And then below average and low, and then very low. What they mean by this desistance line here, this solid line across, this is the rate of non-sexual criminals who subsequently are rearrested for a sexual crime. So in other words, the comparison group is a group of people who are arrested for different other types of non-sexual crimes. And then they follow them for 25 years and say, okay, well, of all the people who are arrested for robbery or non-sexual assault or burglary or drug crimes, how many of them get rearrested later on for a sexual crime? That's called the desistance line. The reason it's called that is because these other lines are trying to determine over what period of time does somebody convicted of a sex crime end up with the same likelihood of being arrested again for a new sex crime, the same likelihood as somebody who was arrested for a different kind of crime. And so I'll just let you ponder that for 1 second and then tell you what the results were. What we know is that the lowest risk offenders on an actuarial risk assessment instrument, the people who are scoring lowest for risk to reoffend, are actually less likely to ever be rearrested for a new sex crime than general criminal offenders. So that randomly selected robber or non-sexual assaulter is more likely than someone who scores low risk on a sex offense to be rearrested subsequently for a repeat sex crime. After 10 years in the community offense-free, even moderate risk sex offenders have rates that are comparable to the person with no history of a sex crime. And after 15 to 20 years living in the community offense-free, even the highest risk sex offenders are no more likely to be rearrested for a new sexual crime than someone with no prior sex crime history. And what we know is that the public registration or notification laws don't seem to be the reason for this desistance, because there were no differences in these trends between offenders in the US and Canada, where no public registry like ours really exists. And so I'm going to come back to this in a moment. But again, when we're looking at these trends, they kind of help to inform our laws in terms of lifetime registration, or how long is long enough, kind of question. At what point does the return on investment, so to speak, become less than the cost, actually, the cost of the resources? And so looking at this, probably lifetime registries are not necessary and probably inefficient for most offenders, maybe not all, but most or many. This is a study that comes out of Florida, and I know you're in Michigan, so I hope you'll just indulge me for a moment. But basically, we studied trying to understand what are the types of crimes that people convicted of sex crimes, people on registries, are actually rearrested for. And first, we removed about 30% of the total rearrests because they were for non-technical violations. So probation or parole violations that would not have been a crime if somebody wasn't on probation. Of the for lack of a better word, I just call them, real crimes, criminal infractions. This is sort of where the breakdowns came, driving offenses, property offenses, substance-related offenses, victimless behavioral crimes, so that might be like trespassing or loitering. Almost 12% with new violent or non-sexual crimes, but of all of those new arrests, less than 5% were for a new sexual crime. Interestingly, failure to register is becoming in most states the most common type of recidivistic offense, and often it's inadvertent, not necessarily intentional.
Hey, Jill.
Yes.
Jill, this is Rep. Filler. We had you, or I have you for 15 minutes. And I want to make sure that you get in all your points because we have a couple other ACLU folks following you. So I just wanted to keep that on your mind if there's anything you want to finish with. And again, we will provide the study to everybody in the committee.
Gotcha. Thank you. I appreciate that. So I think the big question for you is the public registries and their impact on public safety. Most studies, again, across multiple states over time, have indicated no systematic trends of reduction in repeat sex crimes that can be attributed to registration or notification. On the other side, and this is where the balance comes in, I think, for lawmakers, is that there are also collateral consequences that impede successful reintegration. And this is becoming increasingly problematic, I think, as the population in general and the sex offender population ages, with limitations on social services, ability to receive health care in places like nursing homes or rehab centers. So the collateral consequences versus the empirical impact on public safety. This is a study that was funded by the Department of Justice, a 4-state study. These are the recidivism rates. But an important question I was asked that I want to make sure I get to is the idea of an offense-based classification system, which I believe Michigan has, versus what we call an empirically derived risk assessment classification. And what we learned from that NIJ study is that offense classifications based into tier 2, which would be the less dangerous, tier 3, the more likely to reoffend. When that's classified solely on the offense of conviction, it doesn't do a very good job at all of predicting recidivism. And as you can see, actually, the tier 2 had higher rates of recidivism than the tier 3s, indicating that the offense classification was not very good at predicting who would reoffend. Final thought, because I know that you have other testimony coming. What scholars in the research literature and what we know from studying these laws kind of bring up these basic questions. Are sex offender registries, as they're designed and implemented right now, are they fiscally sustainable? Are they cost effective? Remembering that they're very expensive and the costs of those registries may sometimes be taking away money from other parts of a budget that could be used for prevention and victim services. Secondly, to make sure that if we want our laws to be most effective, that they are research-based, that they're based on what we know, even sometimes when the research shows us things that are surprising or that we kind of don't want to believe. But how we can use our resources to allocate the law enforcement resources directly toward those people who truly are most likely to repeat this kind of behavior and victimize somebody in the community. And on the other end, how can we allow for the possibility of removal from registries to encourage successful reintegration in those positive ways that research tells us contribute to protection against reoffending, work, stable housing, family and social support, and being able to engage in positive citizenship. I'll pause there. Thank you.
Okay. Jill, thank you very much. I don't see any specific questions from the committee right now, but so we're going to continue committee. So thank you very much for your testimony.
Thank you.
All right, next we have Larry Dubin from Detroit Mercy Law, professor, and we're going to put a 5-minute clock on this to make sure we have individual, the ability of individuals to testify afterwards. So do we have Professor Dubin?
Yes, I am here.
Okay.
Can you hear me?
Yes, please go ahead. I'll start the clock.
Thank you, Mr. Chairman and the Judiciary Committee members. I would like to very bluntly start off by saying that from everything I know, and I've indicated some of the qualifications that I have, some of the work I've done in this area, that this is a very bad law, HB 5679, in protecting the public. I'm all for protecting the public. I think the intention of the law is well conceived, but the cost to innocent people who are subjected to the harsh factors of this law, I think definitely need to be taken into account by the Michigan Legislature. I just want to say, in terms of my background, I graduated University of Michigan Law School in 1966, practiced for 8 years, been a faculty member teaching law at the University of Detroit Mercy, and now have emeritus status. The issue that I see is, do people who have fully paid their debt to society for their crimes, in this instance, sex-related crimes, deserve a second chance to live their lives in dignity and with full rights of citizenship? Now, maybe there's a small percentage, as Dr. Levinson just mentioned, who can benefit by coming under this type of law. But I think the vast majority do not, and they pay a very big price under the guise of protecting the public. And therefore, it's important for the legislature to be cognizant of the underlying data and research that helps point the direction to those who might actually have a propensity for future criminal action. I think that if we compare our sex registration scheme in Michigan, you see that we have almost 45,000 people on it. We have more than New York State by 15,000, and they have twice the number of citizens. We have more than Illinois and some other large states, larger than ours, who have half the number of people on the registry. So I think that's something that should be taken into account. The very term offender, sex offender, connotes to the public, and it's a highly charged word, that this person has cause for creating problems. And I think that that is clearly an inaccurate term in describing those who show no propensity to commit further crimes. Part of the problem in terms of being a lawyer and in understanding how these laws have proliferated is, and I'll say this very briefly because it's almost hard to believe, but the United States Supreme Court in 2003, in a case Smith v. Doe, in deciding the constitutionality of the Alaska sex registration statute, that was at a very different time and a very bland registration scheme from the one that we have in Michigan now. But Justice Kennedy made a statement in indicating that the law was constitutional. He made a statement that the recidivism rate of sex offenders could be as high as 80%, that it was frightening and high. That was the famous quote, frightening and high. It was shown through subsequent clarification that Justice Kennedy relied upon an article in Psychology Today by someone who had no credentials, who made that statement for purposes of promoting his business interests. And when I say that, you could say, well, that what I must be saying certainly can't be true, but in fact it is. And courts from that point to today have used that term frightening and high relating to that 80%, which is an absolutely inaccurate statement. And I think Dr. Levinson certainly in her presentation confirmed that. So I think that what we have to recognize is that there are a lot of sex crimes that are committed, and one group that I'm interested in are people with developmental disabilities. They often can commit a crime without any intent of hurting anyone, but rather for a lack of understanding of the social consequences of what they've done. And what they oftentimes need to gain understanding of that is some type of sex education that relates to their experience, because they think differently, but have no interest or ability to harm anyone. I have a close relative who fits that, who has autism, who was convicted of having illegal images on his computer, nothing in the background to reflect ever any desire to hurt anyone, has been on the registry now for many, many years without any ever encountering any problems.
Hey, Professor.
And there's research to show
Professor, I just want to
percentage of people
introduce
on the registry also have autism, and it can ruin their lives. I don't think there's any question that this law, which sounds good and interested in protecting people, absolutely ruins lives for people who are on it. It takes away their ability to
Larry, can you hear me?
A normal life, to regain their citizenship.
No, we cannot.
That they're entitled to after having served their debt to society. And based upon that, in terms of loss of jobs, my relative in question wasn't permitted to join a tennis club because he was on the registry, even though that was one of the few activities that he could participate in. Thank you very much. I appreciate the opportunity to speak.
Oh. Thank you, Larry. I don't see any specific questions to your testimony right now, and I do want to make sure we get through a couple more people. We have Miriam Aukerman from the ACLU and Paul Reingold. Do we have those individuals on the Zoom?
Hi, this is, can you hear me?
Yes, we can hear you. Can you hear me?
Yes.
Okay, Miriam, I'm gonna start the clock, and I got you guys for 5 minutes, and I do want to make sure the individuals can testify. So go ahead whenever you're ready.
Sure. My name is Miriam Aukerman. I'm a senior staff attorney at the ACLU of Michigan, and I've been one of the lawyers involved in the litigation around SORA for much of the last decade. We oppose 5679 because what this bill does is ask you to support a failed policy and pretend that it's working. Basically, this bill tries to revive a law that the courts have said again and again is unconstitutional. I think what we've heard today is that our goal here has to be to end sexual violence. And if you care about ending sexual violence, you should oppose this bill. To stop sexual violence, we need to invest in prevention, we need to support survivors, and we need to hold people accountable. And then once we've held people accountable, we need to make it possible for them to go on and lead productive lives rather than sabotaging every productive, useful thing they try to do. And that's what the registry does. It creates a system of people with past convictions to lead positive lives and takes resources away from prevention and support services that actually work. I want to talk very briefly about who's on the registry. My clients are on the registry for offenses that they committed often decades ago. Some of them are children as young as 14. Some of them were involved in consensual sex with younger teens. One of my clients is now married to the young woman in question, they have children together, and yet he was homeless as a result of being on the registry. There are clients with developmental disabilities. One of my clients has fetal alcohol syndrome and has the developmental age of a 9 or 10-year-old. These are the people who are on the registry. There's a wide range of individuals, but what they share is that the state posts pictures of them and extensive personal information, including maps of where they live and where they work. They repeatedly lose jobs, they lose housing, they face death threats, and vigilantism. Michigan's registry is really bloated. It's the 4th largest in the country, about 44,000 people. And that's more people on the registry than live in the cities of Muskegon or Port Huron or Mount Pleasant. That's the number of people on the registry. Michigan's registry is a life sentence for many of the individuals on it. I want to turn quickly, because my time is limited, to the law. The courts have said again and again that Michigan registry is unconstitutional. And in 2005, Judge Clin found that many parts of the law are incomprehensible. People can't comply with the law they can't understand. This bill does not fix that problem. In fact, it makes it worse by creating different rules for different groups of people. It's going to be even harder for people to understand. One of the most incomprehensible parts of the bill is the exclusion zones that limit where people can, severely restrict where people can live and work. The bill tries to fix that, but what it basically says is you have to measure from property lines. So unless you're walking around town with a surveyor, there's no way to know where you can live and work. In 2016, the Sixth Circuit Court of Appeals, noting the lack of evidence that registries actually do anything to protect the public, said that we cannot cast people out as moral lepers based solely on a past offense. Basically, what the court said is that the registry is so ineffective that it is unconstitutional. It's never-ending punishment. And the court therefore said you cannot apply the 2006 and 2011 amendments retroactively. Judge Cleland later looked at that and said the 2011 amendments are so baked into the law that they cannot be separated. What that means in plain English is that the law is so riddled with constitutional problems that it needs a complete overhaul or it will not pass legal muster. This bill is not an overhaul. This bill is tinkering at the margins. And so this bill is just as unconstitutional as the current law. It keeps the 2006 and 2011 amendments almost entirely intact, even though the court said you cannot do that. This is not a case where we have to guess what the courts will do. The law replicates many of the provisions that the courts have already said are unconstitutional. Why would you pass a law that you know is unconstitutional? Why would you pass a law that is counterproductive and defies the science? What the legislature should be doing, yes, you should reform the registry. You have to address the court rulings, but you can do that by looking at model legislation that was developed by the American Law Institute that really is grounded in the science, as Dr. Levinson pointed out, this law needs to be. That should be the starting point. I also want to point out that not only does this law replicate many of the things in the existing statute that are so problematic, but it creates, in many ways, it makes things worse because it creates different categories for different groups. There are going to be 2 groups of pre-2011 people and 3 groups of post-2011 people. What that means is 5 different categories of people. There is no way that law enforcement is going to understand what they need to do, that registrants aren't going to understand what they need
Miriam?
to do. Yes.
Can you hear me okay? We want to make sure that other individuals get to testify today. I know you are listed with Paul Reingold. If Paul has things that he would like to submit to the committee or testify at further committees, then we are more than welcome, and you can work with my staff on that, okay?
Well, I was told that I was going to have 10 minutes, actually. I'd been told that in advance. So
my staff has told me 5 minutes, and I do want to make sure that we get through all the people who we said could testify today. Now, if you want to testify further going forward, then that's fine.
Perhaps I can testify then at another opportunity. I just want to, I guess, conclude by saying that, one of the things that's so unfortunate here is that there had been a work group that worked on this. There was a lot of agreement within that work group, among other things, that there should not be different types of registries, that there should be one unified registry for everyone, because that's what a law enforcement really needs. There is a lot of agreement that could be worked from, but instead what's happening here is that we're trying to there seems to be an effort to push something through when in fact the court has provided a lot more time and said, we have time. We went back to the court, asked for more time. There is not this rush to do things. I want to make that very clear to the committee that you're not under the gun in the way that was represented to you.
Okay, thank you. We have Jessica Zimbelman. Do we have Jessica on the Zoom? Jessica is from SATO. She does oppose the bill.
Thank you for having me this morning, Mr. Chair and members of the committee. I'm here on behalf of the State Appellate Defender Office and the Criminal Defense Attorneys of Michigan to oppose House Bill 5678. I am an assistant defender with SATO, and I also represent Paul Betts. There's a case pending in the Michigan Supreme Court awaiting oral argument about whether SORA violates the ex post facto clause of the Constitution. You have my written comments, so I want to hit on 4 quick points and answer any questions the committee may have. First, even though the Sixth Circuit Court of Appeals has found SORA as a whole to be unconstitutional for those whose offenses were prior to 2011, there are portions of the Sixth Circuit's holding that remain in House Bill 5678 that are unconstitutional. As the Michigan State Police noted, the student safety zones, or as I have termed them, the geographic exclusion zones. The length of registration is still a problem for individuals pre-2011. It is 25 years or 10 years post-incarceration, whichever is later, as well as still for certain offenses, lifetime registration. There remains no ability to petition for removal or any automatic removal after a certain amount of time period has passed without any other sex offense being committed. And there's no individualized assessment of risk. This is all offense-based, and Dr. Levinson talked about this as well. And the Supreme Courts of Ohio, Indiana, and Oklahoma, among others, have found that this is problematic when a registry is based solely on offense and not an individualized assessment of risk. And I'm sure experts can talk about this at future hearings, but there are risk assessments that exist to attempt to measure the risk a particular individual may pose. The second point is that this bill, 5678, bifurcates or perhaps even trifurcates. Some of the language is a little bit hard to follow. Michigan Sex Offender Registry based on who, when an offense was committed. And this is confusing for law enforcement and registrants alike and could create severe notice problems. And even though this might be a cardinal sin for a lawyer to read something, I do want to read a short quote from Judge Cleland's opinion requiring a knowledge requirement. This is Judge Cleland's words. Ambiguity in the act combined with the numerosity and length of the act's provisions make it difficult for well-intentioned registrants to understand all his or her obligations. Moreover, law enforcement officers' disparate answers to survey and deposition questions about what SORA's reporting requirements and prohibitions are highlight SORA's imperfect ability to provide fair notice to all persons who it covered. And that was with one registry. This bill creates at least 2, possibly 3 registries. The third point I'd like to make is that what is left for post-2011 registrants is also potentially problematic. Again, we still have the student safety zones, public internet registry, and the same no ability to petition removal or individualized assessment of risk. But those post-2011 people are still categorized into tiers based on purported levels of dangerousness, but no individualized assessment of risk. In-person reporting requirements for for a multitude of changes. And the bill does make some effort to lengthen those periods of time. And those remaining provisions will also remain subject to challenges. As the Michigan State Police noted, perhaps some vagueness challenges still would remain with this bill. And my last point for this committee to consider today is I would be remiss if I didn't mention the Sixth Circuit's rationale regarding the lack of evidence presented. And the Sixth Circuit had a very substantive record before it to make this finding, that there is a lack of evidence that SORA actually works to protect Michigan's residents and make Michigan residents safer. And I just wanted to leave the committee with that thought this morning, and I thank you for having me join you virtually today.
Thank you so much. Thank you for your concise testimony. We're going to move on to individuals testifying. And also, sorry, no questions, Jessica. So thank you. Jack Wagner, are you here? Okay, you got 3 minutes, and I'll start the clock. And I just want you to be concise and go right to the point. And also, if you have written testimony, you can provide it to the committee, but I would say don't read the written testimony.
Absolutely not.
Tell us what you're thinking, and then we'll go.
Absolutely. I have provided written testimony, so I won't redo that for you. I will just speak here today about my son-in-law. My name's Jack Wagner. I live in Ann Arbor, Michigan, and I'm speaking about my son-in-law and all those affected by the current SORA laws, Michigan SORA laws. I want to tell you a little bit about David. First, it must say something to you that I'm here today speaking on behalf of my son-in-law. If any of you have married children, this should say something to you as well. He's a good man. Let me describe him. He worked and put himself through college, earned a degree from Eastern Michigan in business accounting. He proposed to my daughter, and my 5 other children all gave unanimous approval. This is something unusual in our family, but that's the kind of guy he is. They volunteered at the Hope Clinic food pantry for years, even before getting married, one Saturday every month. He and my daughter attended 242 Church in Ann Arbor, where they would work in the children's and the nursery with kids. But as I said, he's a good man, and even good people can get tangled up in our legal system. The 4 categories of CSC are no way to describe all the different situations. There's individual, as every one of those people, tangled up in this system. Nonetheless, when he gets out of prison, I want the punishment to end there. Unless you fix this, he will be placed on the registry for life. I agree with the Michigan State Police. Get rid of exclusion zones altogether. What makes someone safer if they live 1,001 feet away from a school zone versus 999 feet? There's nothing magic about that number. It wasn't derived from research. It's an arbitrary number. Get rid of it. If you're going to keep the law, which I'd rather you just abolish the registry altogether, but it doesn't sound like that's going to happen. You're going to try and keep this law, then why not put some common sense into it? Use risk assessments, as has been described over and over again. And instead of making those risk assessments occur at the beginning of the person's sentence, why not assess them while they're in custody? Use the professionals that work for the MDOC who come in and can determine when someone has rehabilitated. If the purpose of MDoc is to rehabilitate people, let's give them the credit and the chance to show that. Finally, don't make these requirements so onerous as to exasperate and crush someone's spirit. When David gets out, I don't want there to be a registry. The existing registry is needless. It accomplishes nothing positive on behalf of the people of Michigan or for the registrants. And honestly, you need to throw out House Bill 5679 and really start over to fix this right. I know it's going to take a lot of hard work, but I believe you can do it if your heart is in this. Thank you.
Thank you for your conciseness, and thank you for coming here to testify. Do we have Stanley Miller on the Zoom? No. Okay. Do we have a Michael Johnson on the Zoom? No. Do we have a John Mayer on the Zoom? No. Do we have a Greg Kelly on the Zoom? No. Do we have a Brian Forett? Okay.
He's a speak off the cuff now.
Brian, you're live. Can you hear me?
Mute your phone, Brian.
Or is that a Bruce?
Brian. You know.
Yes, can you hear me now?
Yes, Brian, you have 3 minutes. I'm going to start the clock. And if you provide written testimony to the committee, it will be provided to all the members. And so don't read anything. We want to hear from you. And I'm going to start that clock, okay?
Yes, sir. I just wanted to thank you for your time, Chair and members of the committee. You already have my written testimony, and this is very emotional for me to be able to be on here. I appreciate your time, and I appreciate all the efforts that you're trying to do. But I ask that you please revise House Bill 5679,
Thank you.
not just for me, but for my kids. Because unless you're in this situation, unless you're in this situation where it just doesn't affect me, myself, but it affects my family, my kids not having the chance to be able to also have a normal life because of their friends not wanting to hang out with them, or people saying stuff and they don't understand what's going on, or them being ridiculed. I've been in scenarios where people have spit on me, where people have harassed me. I'm a hardworking member of society. I'm big into God, and I give God all the credit for everything. And I hope that you keep him in mind when rewriting this bill, doing what's right. I'm not saying to throw out the registry. I'm saying to please rewrite it and keep in mind of the people who are affected, not just the people who are on the registry, but also the people's families who are affected by this. It's not just the laws of having to stay at distances, but the fact that I'm not a dad that doesn't want to be there for my kids, because I do, but it's very hard because I can't sit there and support them in their games. I can't go and see them at the schools. I can't do a lot of things, and I don't want them to grow up thinking I'm an absent dad, because when I'm at home, I'm there. I spend every second I can with them. I do whatever I can with them, abiding by the laws. I do everything within my power, and I'm sorry that I'm crying and that I'm emotional. This is just very hard for me. When I saw what was being passed and what was going through, I've been on this for about 20 years now, and I just really want to see some change, but I want to see some change for the good, because again, this isn't just me that's suffering. It's my kids and my family and other people that I know because of my mistake. Yes, I 100% accept my mistake that I have made, but I don't want other people to suffer for my mistake. Again, committee and chair member, I appreciate your time today. I appreciate your consideration for letting me speak. This really means a lot to me and my family. If you could please not put this bill through HB 5679 and please have them put more thought process into it, just not for me, but other people that are also affected by this. If you take that 44,000 people that are on the registry and say you have a family of 4 or a family of 5, now you take that 44,000 and you times it by that number, and that's a realistic number of how many people are actually being affected by this.
Hey, Brian,
Thank you so much.
I've got 2 questions. Can you hear me?
Yes, sir.
Okay. Can you tell us what your conviction was?
750.520E.
Okay, and it was 20 years ago?
Yes, sir.
Okay, and can you tell us one aspect while we rewrite SORA or work on it that you would advise us on? Just one aspect of the law.
One aspect of it, just putting more thought and consideration when rewriting it, like the length of time someone has to be on it.
Okay.
I really think that's most important.
Thank you, Brian. Thank you for your time today.
Thank you very much. I really appreciate you, and God bless.
Okay. Do we have a Laura Galavitz on the Zoom? Okay. Do we have a Don Nickel? Okay. Do we have a Sean Baker? Do we have a Maurice Ball? Okay. Do we have an Angie Hamilton? Do we have a Jeremy Vandercode? Do we have an Andrew Tweedy? April Patterson? Amy Case? Rebecca Brown? Barb Camp? Christan Burgess? Okay. Do we have a Kim Anderson? Let's see if that's the right one.
Hi, this is Kim Anderson.
Okay, Cam, this is State Representative Graham Filler. I'm going to start the clock. Again, if you have written testimony, you can provide it to our committee, and it will be provided to all members. You have 3 minutes, so don't read from anything. We want to hear your story. And then at 3 minutes, I'm going to stop you, and we're going to keep moving, okay?
Okay, thank you. Thank you for the time. I'm from Battle Creek. I've been a taxpayer and property owner in Michigan since the 70s. I'm currently an essential worker as defined by the executive orders, and the parent of a registrant who is also an essential worker. So if you or any of your family members has been hospitalized recently, you probably were in a hospital bed containing mechanical parts made by my son. And if you or any of your family members has taken a store brand over-the-counter medication, you've probably used a medication made by the company I work for. So the fact that you're conducting a hearing under these circumstances troubles me on a number of levels, especially when it involves the discussion of a bill that is such a poor attempt at alleviating the deficiencies of the current SORA. The timing is suspicious to me because the current SORA has been unconstitutional for several years, even though it continued to be enforced until just recently. So I wonder what the sudden urgency is. Instead of continuing to try to fix SORA by tweaking the wording, I suggest that the legislature needs to go back to square one and reevaluate the intent of the registry. Section 28.721A states, the legislature has determined that a person who has been convicted of committing an offense covered by this act poses a potential serious menace and danger to the health, safety, morals, and welfare of the people, and particularly the children of this state. I wonder how the legislature continues to make this determination when it is so convincingly and completely refuted by the data. I wonder if the true intent is instead to score political points by capitalizing on widespread public misconceptions about sex crimes, recidivism, and registry effectiveness. Section 28.721A goes on to say, the registration requirements of this act are intended to provide law enforcement and the people of this state with an appropriate, comprehensive, and effective means to monitor those persons who pose such a potential danger. The irony is that the registry and its punitive aspects only serve to undermine those things that have been proven to reduce recidivism, namely stable housing, stable employment, and a support system for registrants. In other words, the registry not only doesn't enhance public safety, but actually serves to erode public safety. A particularly egregious example is the school safety zones, which only serve to limit the housing and employment opportunities for registrants. And the problem of vagueness with current law is not alleviated by the addition of property lines to the definition. Given that the data shows that
Kim, can you hear me? Can you hear me? It's Rep Filler.
Yes.
We're at 3 minutes here, so I want to make sure that individuals, because we do have a lot of people here, so can you give, we understand exactly, you are very clear of what you'd like to see going forward. And so can you give just a closing statement real quickly?
Yes, I'm particularly troubled by the school safety zone aspects of this, and also the harm that this causes to the families, as the prior person who testified most excellently conveyed.
Okay. Thank you. Thank you. Yep. Thank you for your time. We have Christan Burgess available. Is that correct on the Zoom? Okay, Christan, can you hear me?
I can hear you.
Okay, same show. You have 3 minutes. Don't read. We'd like to hear whatever story you have. And there may be some questions, and if not, and you want to submit written testimony, the committee will review that, okay?
Okay.
Okay, go ahead.
All right. My name is Christan Burgess, and I'm the mom of a sexual abuse survivor. I'm also the wife of a sexual abuse survivor who became an offender. I did submit written testimony, and I am opposed to Bill 5679. The registry has failed at protecting families, but it has succeeded at destroying them. My family is a victim of intergenerational trauma, child abuse that devastated my husband's childhood, sexual abuse that stole his innocence. When he reached out for help, he was told to get over it. And decades later, when my husband lost his job of 23 years, he spiraled out of control and he sexually abused our teenage daughter. Representative Lower says he's speaking for victims and putting forth legislation that protects people, but the evidence is in. The registry doesn't protect, and it does deter, and it does help stop funding that should go to the health. Where is the funding for primary prevention? Where was the funding to talk to men about trauma, abuse, and men include them? Where were the people to teach them that there were health ways for men to deal with that men too can break trauma cycles? Where were victim services? Where were mental health services? Was that funding tied up in Michigan's bloated prison system? Was it being used to destroy healthy families? And was it being used to destroy healthy futures by funding a registry that has no basis in evidence? It wasn't there for my family, and it's still not. We asked the system for healing, and we had treatment providers come alongside us. They assessed that my husband was a good candidate for community supervision, and my now adult daughter wanted to explore restorative justice. Instead, we have a 12 to 30-year prison sentence. The MDOC spends $40,000 a year incarcerating my husband while I raise 8 kids on food stamps and prayers. And it won't stop there. My husband can't even live with his mom and pay child support. And once we're free of the living hell that is trying to find healing through razor wire, my husband will be a senior citizen facing life on a public registry that does not keep the public safe. His chances of finding work will be essentially zero. I'll still have minor children to raise. Dr. Cheryl Kubiak said that victims don't all speak with one voice, and she's right. Our system should be flexible enough to honor healing, and our system should be smart enough to fund primary prevention. Here's the truth. This emperor is wearing no clothes. We're wasting money funding draconian prison sentences and a soul-shattering registry when the evidence is clear. These measures aren't keeping people safe. Instead of funding victim services and helping families devastated by generations of sexual violence and other trauma, we're burying our heads and our money in the sand. You pat yourselves on the back for thinking of victims, but you don't think about us at all. Put your money where your mouth is. Fund primary prevention. Fund victim services. This system has stolen my children's financial inheritance, and it has stolen my family's chance to heal from generations of sexual abuse. This registry bill will do nothing to keep Michigan safer, but it will destroy lives, steal our money, and destroy people and families who deserve a second chance.
Okay, Kristen, thank you so much. Thank you for being concise, and I hope you have a nice day. I have a Dave Lubin, okay? Dave, can you hear me?
Yes, I can hear you. Can you hear me?
Yes, I can. So you got 3 minutes. I want to hear your story. I don't want you to read a script. And we'd like to hear your thoughts on the bill and any advice you have for the committee, okay? So go ahead.
Yes, my name is Dave Lubin, and I'm on the offenders registry. And what I've heard from the several people before, the registry is faulted. It doesn't, people change. I have changed. And if I change, the registry should change. People should get a second chance. I've gone to classes and I have proven myself to the people that run the classes for sex offenders that I have changed person. And my chance of ever repeating are about 0. It has affected my wife and my relationship. It has affected my relationship with my 8 children. 5 of the children have basically chosen nothing to do with me, and that's because of the registry, because it affects them also. I can't go to I have 21 grandchildren. I cannot go to any of their functions. The registry needs to be changed.
Okay, thank you for your testimony. When were you convicted and what were you convicted of?
Pardon me?
Oh, I'm sorry. When was your conviction put into record?
My conviction was in 2017.
And what was the conviction for?
CSC, it's level 3.
Okay. Thank you for your testimony. I don't see any questions from the committee, so thank you.
You're welcome. Thank you.
Cory Bast.
Yeah, Cory Bast. Thank you.
Okay, Cory, same deal. 3 minutes. Want to hear your story, and if there are questions from the committee, we'll let you know. Go ahead. I'll start the clock.
All right, thank you. I appreciate your time this morning. My name is Cory Bast. My crime is child sexually abusive commercial activity. My crime is actually for writing letters. I actually never physically done anything to anybody. I received 5 years, and after getting out of prison in 2006, I was on the registry for 25 years. I've been on it now 21 years. But since then, I don't have no children, but I can't go to my nephew's schooling. He asks me all the time, when am I going to go to a basketball game? When am I going to go to his football game? I can't do that. I've been denied multiple housing, from rental properties to apartment complexes. And even though my credit score is great, I've been out of prison since 2006. I still have to basically live with family because I can't really find any good housing. It's just been a living nightmare in a sense where even multiple job offers have been denied, even though I qualify for the job. As soon as they check the registry, they automatically deny it. So yeah, I would hope that you guys oppose and revise HB 5679. I think it should be getting rid of and rewrote, but at least just use common sense and make the changes that need to be constitutional and that are the right for everybody.
Cory, can you hear me okay?
Yeah.
Can you speak to maybe one aspect of the registry for our committee?
One aspect I would say just the length of time and it being maybe more just for the state police and not to the public.
Okay. All right, Cory, thank you for your time. I don't see any questions from the committee. Thank you.
Thank you.
All right, we're going to take one more here. Maybe a Vicky Hanlon's. Okay.
Hello.
Vicky, can you hear me?
Yes, I can.
All
Can
right.
you hear me?
Yes, I can. You have 3 minutes, and please don't read from a script. Please tell us whatever story you have to tell, and then we will ask questions if we have them. And go ahead, please.
Thank you for your time. I'll try not to read it directly from my script, but I do have to keep notes so I don't go down a bunny trail. I'd like to speak to the issue of having a mechanism to come off the registry, especially for those whose records have been expunged. But I think I'm also for a risk-based system and not an offense-based system. Let me tell my story. On April 26th of 2006, my son had just turned 17 years old. A few days later, he engaged in what used to be called heavy petting with a 13-year-old who had been pursuing him. There was no penetration or force of any kind. Unfortunately, the girl changed her story and it became a he said, she said situation as to the events. Of course, he was charged as an adult with CSC4, and because of her age, there was no defense. He pleaded to attempted 4th degree CSC. He served no jail time. He successfully completed probation and was discharged after 1 year instead of 5 years. He paid his fines cost. He was placed on the SOR for 25 years. He's considered tier 2. We live in a small community in northern Michigan, and as you can imagine, the gossip was like wildfire. He went to school where his peers called him a child rapist. He faced suicidal thoughts. His self-worth plummeted. His future goals crumbled. This vibrant young man who had never been in legal trouble, who was well-liked by his peers, he was a varsity wrestler, a good student, active in his youth group, who helped build a community skate park, and all of a sudden he felt like a leper. He persevered. He finished high school, he got married, he had a child. He remained living in the same small community. He maintained employment, although he did have many hurdles to overcome to get employment. He then got divorced, and interestingly enough, he won sole custody of his son. He remarried, had a daughter, and divorced again. Issues of relational trust with women have been difficult. He learned how to survive while wearing the proverbial scarlet letter. Surviving for him, though, has been like swimming upstream every step of the way, and sometimes he has to come up for air when others try to drown you. The years after age 17 are considered important developmental times. We know that the adolescent brain is not yet developed. That's a stage where they're finding identity and industry as a young adult, forming family and community ties, and all of these steps were hampered severely in his life. Finding employment, going to college or trade school, participating in church or social events, these were also all hampered by his status on the SOR long after his probation ended. In 2011, 5 years post-conviction, he petitioned the court to have his record expunged. and thankfully he was successful. However, it did not relieve him of the burden to have to continue his SOR reporting, paying the annual fee, and remaining on the public registry. It certainly did not relieve him of the stigma and public shaming that has continued as punishment long after even his record has been expunged.
Hey, Vicky?
Yes.
Vicky, we've got some time constraints here. You did a very nice job, though, especially at the start of laying out for what you'd like to see on the registry. And so thank you for testifying. If you have written testimony, you can provide it to our committee, okay?
Thank you for your time.
Okay, thank you, Vicky. We have John. John, you know the deal. I'm going to start it at 3, and I'm ready when you're ready.
Okay, I'm ready.
Okay.
My name's John Gorley. I'm the father of someone on the sex offense registry, and I'm a member of Michigan Citizens for Justice, which is a support group for people who are on the registry as well as their family members and friends. I want to come to this very briefly from a slightly different angle. You've heard technical, scientific, legal reasons that there's problems with the bill. And you've heard personal stories, and I want to kind of find a middle ground that in my work with Michigan Citizens for Justice, I've gotten to know something like 4 dozen people on the registry quite well. I call them friends. Those people, to a person, have lost jobs because they were on the registry, simply because they were on the registry. I know people who have been evicted from their apartments after paying rent for years, simply because they were on the registry. I know people who have school-age children and they can't participate in school activities. I know somebody who won't attend his legislators' town halls because they're often held within 1,000 feet of a school. I know 2 people who've committed suicide because of the really severe, horrible conditions that they feel that they have to live under. All of these people were offense-free for many years, 10, 20, even 30 years, and they were still suffering in this way. What's the purpose of Michigan's SORA? It's to try to keep people safe. It's to try to stop sex offenses. How does making somebody homeless make us safer? How does denying somebody a job make us safer? How does impoverishing a family with children make us safer? Also, we need to think about who commits these offenses. As you heard from Jill Levinson, they're not the people on the registry. They're people that are known and trusted by the victims. And so what the registry does is it concentrates law enforcement resources on the wrong people. So I oppose the bill, of course, as it's written. And what I would like to see instead is a bill that's designed around the evidence that you've already heard, and I'm sure you'll hear more of, and one that concentrates on prevention rather than punishment. So thank you very much for the time.
Thank you again for testifying. All right. So just a quick overview going forward, and then I'm going to give you 2 minutes, David. There will be multiple hearings on Representative Lauer's bill. If written testimony is provided to my office, it is always provided to the committee members. And then just broadly, we have handled complex judiciary issues throughout 2019, 2020. This is in no way rushed or somehow a fog of war concept. We are aware that at some point the judge will issue the order and there will be a shot clock. And so we want to get that going and be very open and transparent, as we always are. We want to thank the people who have testified, and people will have the ability to testify going forward. And so that is my statement. David, you got 2 minutes?
Thanks, Chair Fuller. So, colleagues, I want to start by telling you reminding you that I was in the prosecutor's office in Kent County for 8 years, and I did appeals work. So I handled a lot of scary, awful cases on appeal. Murderers, rapists, people who were scary and were appropriately in prison for a long time. I also spent a lot of time prosecuting domestic violence cases. So this is something that I have a real background in. And one of the things that I want to point out is that, you know, the earlier comment about, you know, maybe an overblown, you know, scare tactic, calling these people, you know, calling sex offenders recidivism rates frequent and scary. Well, it can be infrequent and scary too. So I think all of us have to really be committed to stopping infrequent but awful things from happening. And if we can craft legislation that will give us public safety, that is what we should do. We've heard a lot of testimony, and I think there's a lot we have to digest here, but I want to break this down and maybe oversimplify it. From my perspective, this looks like a little bit like if you've got a state trooper rolls up to your car and says, your car's on fire, your front bumper's missing, and your license plate's expired. And the response is, well, I'll get right on renewing that license plate registration. There are 3 big issues here, and this bill as drafted only deals with the third and least important, which is how can we perhaps address some technical concerns that a judge has raised about the sex offender registry. Now, I think that Representative Lauer is absolutely right that a question of whether we should scrap this registration may not be the right time to have that conversation. But I do think that we should be about justice and good public policy, and I think that there are 2 important things that we need to consider and that I absolutely want to have considered as part of this bill before we move any further on it. The first is what I think is an unworkable and overbroad school safety zone mechanism. I think that it's poorly crafted and technically fixing it is not sufficient. The second is that I think that this registry is overbroad and includes too many people. And any registry that has a lot of false positives becomes a bad tool. I think that a registry that identifies people who are dangerous and monitors those dangerous people can be a useful mechanism. But I think we have real work to do, and I want to give you 2 examples. Right now, you can get on the sex offender registry for parental kidnapping, something that has nothing to do with sexual activity. Second of all, you've heard a couple instances of CSC fourths. A CSC fourth is a touching over clothing for the purpose of sexual gratification. And the woman who just testified last was talking about that. I think we have to really consider whether we want, for example, indecent exposure, gross indecency, and CSC fourth to be registrable offenses. And I do not have, frankly, enough confidence that we will revisit this issue later to say that we should pass a couple technical fixes now and trust us we'll get back and re-examine the justice of the SORA registry later, or the good policy of the SORA registry later. I absolutely think that we have to make some good policy fixes to this, and while I welcome Representative Lauer's work to fix some of the technical problems that the judge addressed, I think that is a necessary but not sufficient, and not even close to sufficient, response to the problem that's in front of us. So thank you for giving me the time, Chair.
Thank you, Representative. Thank you, committee members. And we're going to excuse the absent members. Okay, we already did that, so we're adjourned.